Use of a generic names of a drug. Every physician should, as far as possible, prescribe the drug with a generic name. Only thing word, as far as possible, has safeguarded by doctor, otherwise it would have been compelled. But new NMC draft are compelling doctor to write generic. As far as possible means they can write, they may not write, but possibly they should write. That reason pharma companies are still existing. Otherwise, pharma company would have to reduce their rates, shall ensure that there is a rational prescription and use of a drug. So rational prescription, as I said, complaint has been filed on the basis of 12 drugs written. There was a mini doctor who write 12 drugs, 12 to 14 drugs written on a prescription by a doctor was taken to the court. And the same thing was highlighted. Where is the rationality for everything when drug is prescribed? Where is the rationality? So naturally, this need to be kept in mind. Highest quality assurance in the patient care. Exposure to unethical conduct. Physician should not expose without fear and favor incompetent or corrupt, dishonest or unethical conduct. So nowadays, this become very important. As I said, there was a case happened in Maharashtra where in a Pune, some CT scan center has sent a check of 600 rupees to this particular doctor who was practicing in Ratnagiri or somewhere nearby area as a cut for referring a patient for CT scan to Pune, which probably doctor were not aware and not wanted because he was ethical doctor, he was honest doctor, never wanted to have a, or may got feared because it came in the form of a check, because it become evidence. Either of the two reasons. But that person has filed a case in Maharashtra Medical Council for unethical practice against the CT scan center, the doctor, for doing corrupt practice by giving him a bribe of 600 rupees. So now that has taken a crop. I know a case where a PRO of a hospital, of a doctor, ran away with a diary, with a cash, because he was being instructed to distribute the packet of a cash to the general practitioner who are referring a patient, and he was given responsibility to take a signature on a paper where in a diary detail of everything was mentioned, normally very hospital, the name of the patient, admission date, discharge date, amount bill, charge, everything, and his share. And then signature, because even GP wanted that I need a transparency. He ran away with the diary because he was removed from the job of some reason, and he ran with diary and then demanded a lakh rupees from the hospital, saying that if you don't pay me as a settlement of being with you for this number of years, I will force to go to medical council with this evidence of a diary and file a complaint against you for unethical practice. And this was the real case. These things are happening in our country. So be careful when your client calls you, and highest quality of assurance to the patient. Payment of professional services. Very clearly guided, physician engaged in practice of medicine shall give a priority to the interest of the patient. The personal financial interest of the patient should not conflict with the medical interest of the patient. A physician should announce his fees before rendering the service. No doctor does. But they should display it. Even law expect that consultation, 2,000 rupees, follow-up, 1,000 rupees, whatever they need to display. So they need to announce fees and not after the operation or a treatment is underway. Even for the surgery, even for remuneration received for such service should be in the form of amount specifically announced to the patient at the time of service rendered. It is unethical to enter into contract of no cure, no payment. Physician rendering a service on behalf of the state, and this is many of the time as ground yesterday. There was another doctor sitting with us who was narrating his story that his case was filed only because the excess charge to the patient because of the complication happened thereafter. So natural bill of the hospital has gone a little high, and only on the basis of that complaint was filed. I have been told about 1 lakh, but now bill has gone to 2 lakh, and that can be a ground for unethical practice. Evasion of legal restriction, patients shall observe all the laws of the country. They have very, very clearly mentioned the laws need to be observed by every people. Naturally, duties of physician are very much defined. Now, on the basis of duties of physician, we are expecting new law in the country, which is known as patient chartered bill. Sooner or later going to come. On the same ground, Karnataka Medical Council have brought patient charter regulation, which was strongly objected by medical practitioner. So they have, since there was a clause that it can be implemented once the authority decides that there is not implemented, everything was mentioned. So patients' power has been enumerated. So here, what are the duties of patient prospection? Lastly, everything needs to be explained to the patient detailed before the treatment. Medical practitioner should give all care to the patient. Prognosis, delicacy, secrecy need to be maintained. As we always talk about privacy and secrecy, prognosis, wherever physician fees need to be explained, but it should not be exaggerated or not be minimized. So many of the time it get exaggerated for want of something, so that patient should not run away from them. So that not to be exaggerated. They should not be neglected. Means when the patient is free to choose whom he will serve. So first line, what they mentioned, I have got all the right to refuse the patient. If I have the right to choose, deemed meaning that I have got right to refuse also. He should, however, respond to any request as an emergency. Emergency, he cannot refuse. Once having the undertaking the case, physician not neglect the patient. So if you have done an ANC registration for 9 months, then you cannot suddenly throw away the patient, nor should he withdraw from the case without giving adequate notice to the patient and his family. Provisionally or fully, registered practice shall not willfully commit an act of negligence to. So everything is mentioned under that. Yes, new NMC draft definitely spoken about that if at all payment is not been done by the patient, you have got all the right to intimate the patient and withdraw yourself. But there's a ground. Engagement on obstetric case, as I said, physician should have been engaged to attend obstetric case in absent, another is sent. So if at all one gynecologist is absent, it is the duty of a gynecologist to make arrangement of other gynecologist who is also entitled to have a fees and consent to continue the patient. Physician duty for the consultation also enumerated. Unnecessary consultation should be avoided. Very clearly, they said the frivolous consultation should be avoided. Consultation of the patient's benefit. So all the things need to be taken care of. Punctuality in consultation, which has not been found in professionals. We give a 10 o'clock time, we reach at 12 o'clock because of multiple assignment which every doctor has got. But law says that punctuality, and I have got a case where on this basis also been complained and gone to the various authorities that I have waiting for doctor for 2 hours and not be treated, and this is very common now. Statement of a patient after consultation need to be checked. Treatment after consultation to be properly be given. Patient referred to other specialty wherever one specialty fee that is not my field, it should be referred to other specialty. Fees and other charges are also been defined. Patient should clearly display his fees. Repeatedly been said in Act. Patient shall clearly display his fees. This also can be ground for unethical practice and other charges on the board of his chamber and of the hospital he is visiting. Prescription should not also make a clear if physician himself dispense any medicine. So beautifully narrated, but not been followed. And the complainant who knows these laws are capable of filing a complaint, because any of the thing which has not been followed comes under unethical practice. So even if it has not been followed, can be a ground for filing a claim in medical council. Patient shall write his name and designation in full, along with the registered particular in his prescription letter. In government hospital, patient load is heavy, the same name of the prescribing doctor must be written below his signature. So everything has been defined properly, my friend. Naturally, to each other, doctor versus doctor, dependence of physician to each other is very common. Conduct in consultation has also been defined under the law. How and what way this can be done. Consultation for taking the fees, appointment and substitute, listing of another patient cases are everything been elaborately defined under the Act, which every doctor must need. Same has been defined under the duties of physician to public and paramedical profession. Paramedical means nurses, ward boy, ayabais, physician as a citizen, public community health, and pharmacists and nurses. Everything. If a physician should recognize and promote the practice of different paramedical services, such as pharmacy, nursing as a profession, and should seek their cooperation whenever required. So everything has been narrated. And what they said, the violation of any of the provision from chapter 1 to 5 will be termed as unethical practice. So whatever we have read here, if anything is violated, is going to be unethical practice, actionable under medical counsel. And then chapter 6 and chapter 7 is a very important chapter because each chapter actually talks about unethical practice or etiquette violation and the procedure aspect of arguing the matter and also of the procedural aspect of appealing to various body. And this chapter is really important when I talk about medico-legal consultant learner batch, because they are going to defend either patient or a doctor. For them, 6 and 7 is actually their domain. So we will take that in next session because it is going to take another session that needs more attention, more time. So I purposely kept that 6 and 7 for next session so that I can put a proper time because that is the very important aspect. Chapter 1 to 5 was a ground. I am going to send this to you tomorrow. My request is that you please read all the things prior to next session so that 6 and 7 become more understanding to you, more clearer to you on the basis of which you are going to practice. So I take a question answer session by stopping here today's session. And if you got anything in your mind, you can raise your hand. You can discuss with me so that we can have a more clarity on the subject. And then we can go for 6, 7 years. Yes, Pawan, you can go ahead. Pawan, Kalyani, you both are allowed to speak. You can just.
Sir, good morning, sir.
Morning.
Sir, is there any difference in the retention period of records for scan centers for hospitals, or it is the same 3 years for all the clinics?
Can you repeat?
So the retention period for maintaining the medical records, no? You told that we have to keep the records for 3 years.
Right.
In our setup, I am from Tamil Nadu, sir. Here they are telling that we have to keep the records for 10 years in hospitals.
So we need to see your law because see if at all they have amended KMC Act, then we need to check. But by and large, KMC Act definitely for the state, but KMC is also governed by the National Commission, that is NMC. So whatever rules made by NMC are bound to be followed by KMC also. So 3 years they have mentioned by NMC, now MCI. So it's going to be dictum, but let me tell you, 10 years if they are saying, then probably they may be saying about FLC cases till the time it dispensed off, or on various other act which very clearly mentioned about that. But 10 years, if at all they're saying you ask some provision, if it is there, some written part is there, so that I can really guide you on that. So whoever is saying, see, orally, people can tell 10 years, 15 years, 5 years. I say orally to all my people that at least 5 years we keep. Because in court of law, delay condolation for 2-3 years has been possibly observed. So 3 years plus 2 years, 5 years, we always advise for a safer purpose, not as per the law. Law says 3 years. But if someone is saying 10 years, try to find out under what provision it is mentioned. I don't think it is going to be 10 years.
Thank you, sir.
Yeah, Pawan. One. Anyone else has got any question? No problem. We will meet on next session and we will go with the chapter 6 and 7. We will finish with Medical Council Act for all my learners. So thank you very much for being with me this morning and be safe, be secured. Let's meet on next Sunday. Next Sunday timing may differ. It may not be in the morning. It may be in the evening. So please confirm with the global people. Thank you.